Hi, if you're here, that probably means you have some questions about whether or not you need to update your will, your trust, your living will, healthcare directive, or other planning documents in the event you move to another state. In fact, it's one of the most common questions we get in our office. Hey, if I move to another state or if I buy a home in another state, do I have to update my estate planning documents? Well, in today's video, we're going to answer that question. We're also going to share with you some of the things you should be aware of if you are considering moving to a new state, actually move to a new state, or like many of my clients, where maybe you live in Minnesota, Wisconsin, the Midwest, and you're buying a home in Florida or Arizona and splitting time. Hi, I'm Chuck Roulette. I'm an attorney who's licensed to practice law in both Minnesota and in Florida. And we have offices and staff in both locations. We have an office in Minnetonka serving our clients and their families in the Twin Cities and throughout the state of Minnesota. And we have an office in Venice, Florida, just south of Sarasota, serving the Gulf Coast and our clients and their families throughout the state of Florida. And so in today's video, we're going to talk about what you need to be aware of if you are thinking about moving or perhaps buying a home in another state. So let's start by sharing some of the things that you should be aware of if you're thinking about moving, or even again, if you're just thinking about buying a second home. So for example, many of my clients will have a lake home in Wisconsin or farmland they inherited in Iowa or Nebraska. Many more are buying a second home in Florida and becoming snowbirds, or in fact, relocating to Florida, becoming Florida residents, and then maybe maintaining a home back up in Minnesota, Michigan, Wisconsin, Illinois, Pennsylvania, and then going back and forth. So if you fall into that category, you're going to want to pay attention. So the first thing to be aware of is many states have state-specific financial powers of attorney. So again, a financial power of attorney is a document wherein you usually would name a spouse or one or more friends or family members to manage financial affairs in the event you were to become incapacitated. And many states will have a specific state form of the power of attorney. In fact, Minnesota has a statutory form and Florida has a specific Florida form. So again, the first thing to be aware of is if you don't have one, your family may need to go to court to get the authority to manage your finances in the event you become incapacitated. But again, many states will have a specific form of power of attorney. And so even though you may have one in place already, if you are going to move to a new state or you're going to own property in another state, it's a good idea to at least check in with an attorney in that state if that state does have a specific form of power of attorney, and then to get one of those in place. Or even if that state doesn't have a specific form of power of attorney, to make sure that the one you have will actually work in that state. So that's the first thing to be aware of, is making sure you have the right financial power of attorney. Now, the other thing to be aware of is probate requirements can vary between states. So first, one of the biggest misunderstandings I see in the general public when it comes to estate planning is they think that if they have a will, their family doesn't have to go through probate when they pass away. Unfortunately, not true. A will does not avoid probate. In fact, a will is a set of written instructions to a probate court about how you want probate to occur. So if you didn't have a will or other planning documents in place and your family would have to go to the court upon your passing, the court's going to get to decide who's in charge and where everything goes based on state law. Generally, you don't want that. So a will is a document that would tell the court, hey, if probate's necessary, here's who I want in charge, here's where I want it going, here's how I want it getting there. So those rules and what triggers probate will vary a bit by state, and probate costs and timelines can vary by state. So for example, I have a colleague who practices in Pennsylvania. Pennsylvania has a relatively fast and inexpensive probate process. On the other hand, Florida's probate process is not inexpensive and it's not fast, neither is Minnesota's. So if by chance you're coming from a state that has a very simple or fast probate process and coming to a state like Florida that doesn't, if you've got a will in place, you may want to seriously consider changing your planning documents to a trust, for example, to avoid probate. So that's one thing to be aware of. Now, another thing is if you are going to own assets in more than one state, and again, many of my clients do. Again, they may have their main residence in Minnesota and a lake home in Wisconsin. They may be up north and have a winter home in Florida. They may become Florida full-time residents and maintain a residence back up in Minnesota or another state. So if you have assets in more than one state, then you're not going to want to have a will in place. So if you have nothing in place, it's probate with the court making the decisions. If you have a will, still probate. But here's the catch. So let's assume for a moment that you have moved to Florida and you're now a full-time Florida resident, but that you maintain a second home back up in Minnesota, for example, and you go spend the summers up there on the lake with the kids. Well, if you were to pass away, your family's going to have to open probate here in Florida because that's now where you're a resident. But the Florida court doesn't have jurisdiction over the assets back up in Minnesota. Only the Minnesota courts do. So your family's going to have to open a second probate in the state of Minnesota to deal with the home in Minnesota. Now, if you're a full-time Minnesota resident, have a place in Wisconsin or a place in Florida, reverse the process. But the point being is your family's going to have to open probate in 2 states, which significantly increases the cost, timeline, and just overall stress for your family. So if you're going to have assets in more than 1 state, you're going to want to make sure you have a trust in place. Now, another thing to be aware of is some states are going to have different tax laws and different tax considerations. So for example, some states are community property states. Some states are separate property states. Some states like Florida are separate property states, but allow a married couple to choose to treat assets as community property and save on taxes. Some states like Minnesota have a separate state level estate tax, whereas some states like Florida do not have a state level estate tax. And again, the differing tax laws may require updates to your plan if you own assets in more than 1 state or plan to move to another state. So again, just because you've maybe moved from a state that doesn't have an estate tax, down, say, Florida, but if you have assets in another state, you may still be subject to the estate or other tax laws in that state because of those assets. So if you are relocating, it's going to be worthwhile to meet with an attorney to make sure that your plan accommodates that. Some states have different formality requirements on how documents need to be signed. So for example, in Minnesota, a trust only requires you to sign it in the presence of a notary. A power of attorney only requires you to sign it in the presence of a notary. However, other states like Florida require the documents to be witnessed as well as notarized. So there's different execution requirements on the docs. Homestead and other laws may vary. Florida has wonderful homestead protections. However, this is a trap for a lot of the unwary, particularly, again, those who maybe set up a will or a trust in another state and move down to Florida. Your Florida homestead can be lost if you transfer it into a trust and it doesn't have the correct language in it. So again, here in Florida, a trust has to have some very specific language in it to preserve the homestead when it's transferred into the trust. Another thing to be aware of is the rules on protecting your home and life savings from long-term care and nursing home costs can vary by state. So for example, if you worked with an attorney to protect your home and life savings from long-term care costs, or if you haven't done it yet and need to, you should be aware that the rules and the requirements can vary a great deal by state, and what works in one state may not work in another. So for example, again, we work with a lot of clients that split their time between Minnesota and Florida. And when we do that, we carefully tailor their planning to not only avoid probate in both states, but we also tailor it to minimize taxes, and we can even help them protect their home and life savings in the event they were to ever need long-term care or nursing home costs within what are very different requirements between the 2 states. Other states, for example, may require you to record a financial power of attorney with the court, while as other states do not. So as you can see, whenever you move to a new state, or even if you are just purchasing a home or other assets in that state, it's a good idea to meet with an attorney to review your estate plan to make sure it's going to work when your family needs it. So if you would like to learn more about why your existing estate plan, or lack thereof, will, trust, whatever it may be, may fail just when your family needs it most, and how you can put a plan in place to make it as easy and expensive as possible for your family while protecting your assets, I'm going to be holding a free online master class, and I'll be revealing the things you need to know about powers of attorney, living wills, healthcare directives. We're going to discuss wills versus trusts, why you might use one or the other, or sometimes even both. We'll discuss tax minimization strategies. I'll even reveal some of the strategies and tactics I use with my private clients to help them protect the assets they leave for their family. For example, in the event their kids ever get divorced, get sued, have a medical emergency, we can actually design the plans to protect the assets for them. So again, there's a link in the description below to the free online masterclass. And if you'd like to learn more about how you can protect your home and life savings from long-term care and nursing home costs, download the free guide I've created, Save Our Home, How to Protect Your Home and Life Savings from Long-Term Care and Nursing Home Costs. Again, there's a link in the description below, or you can visit saveourhome.com and get that free guide. And if you have any questions about powers of attorney, living will, healthcare directives, wills, trusts, how to protect your assets, post it in the comments below. If I see it, I may answer it in an upcoming video. So again, check out the free online masterclass to learn more about how to protect your assets, and then download the guide to learn more about how to protect your home and life savings from long-term care and nursing home costs. Hope you found this video helpful. Be well. We'll see you soon.